Hello, I'm Julie Dimauro with Thomson Reuters Regulatory Intelligence in New York. Joining me today is Howard Fischer, a partner at Moses and Singer LLP in New York and a former senior trial counsel at the Securities and Exchange Commission. Welcome to our studios, Howard.
Thank you for having me.
Howard, the Supreme Court just recently ruled in a case called Lorenzo versus the Securities and Exchange Commission about Rule 10b-5 of the Securities Exchange Act. So something that we've been, hearing about in the past, but there's a new spin to it in terms of the false and misleading statements and fraud schemes that could be alleged under Rule 10b-5. Can you explain what the ruling holds and its impact on the securities industry?
Sure, and let me explain also why this was so surprising to those who practice in this field. About 10 years ago, in 2011, in the Janus case, the Supreme Court said that unless you are the specific author of a misstatement, you can't be held liable under 10b-5b for that misstatement. So if you were just sending someone else's statement, even if it's false, you can't be held liable under 10b-5b. Couldn't be under 10b-5b. So the law developed after this to divide the kinds of liability that the Exchange Act prohibited under 10b-5. There was speech acts, omissions and misstatements, which were widely perceived to be only liable under 10b-5b. And then there was schemes to defraud or courses of conduct of business to defraud under 10b-5a and 10b-5c. And it was well accepted in the industry, at the SEC, and at all the businesses that participated in the business of securities, that if you have a misstatement, you can't be held liable under scheme liability provisions unless you were the author of that misstatement. And in fact, just a week before the Lorenzo decision, the Southern District in the SEC versus Rio Tinto case held that you can't have a misstatement be the basis of a fraud claim under 10b-5a or c. And this is where Lorenzo comes in. Mr. Lorenzo worked at an investment banking firm. He was told by his boss to send emails to his clients which misstated the amount of assets that a company had that they were going to invest in. He was the disseminator of that. So when this came to the Supreme Court, everybody expected more or less that the Supreme Court would hold that if he's not the author of it, he can't be held liable under 10b-5b, and because it's a misstatement, he can't be held liable under 10b-5a or 10b-5c. Shockingly, the Supreme Court held that sending out statements, if you know that they're fraudulent and you intend to defraud the customer, actually is a liability under 10b-5a and 10b-5c. This was surprising.
Okay. Now, that's hence all the attention around it. Now, the securities industry and the professionals that are a little bit worried right now, do you think that they have reason to be this worried? I mean, it does seem to expand the universe of liability under that rule. What do you think? Or maybe we're exaggerating the concern here.
Well, I think they should be concerned, and they maybe shouldn't be concerned as much as they might be concerned. Now, after the decision came out, the SEC announced, or at least its enforcement personnel announced at a conference, that they saw this decision extending beyond mere dissemination and including other kinds of misconduct as well, which was also surprising. So people should be concerned because the SEC, or at least its enforcement personnel, intend to take an aggressive view of this. On the other hand, courts tend to be a bit more conservative, and I think it's more likely than not, although we'll see, that courts will hold the Lorenzo decision to its facts. That is, did you intend to defraud? Did you present yourself as informed and as the author of the decision, even if you weren't? And did you hold yourself out as authoritative? And I think a lot of courts that are going to be following these decisions are going to tend to be a little bit more restrictive in their analysis than the SEC might like.
Okay, that makes sense. Now, thinking about advisors and broker-dealers that are particularly concerned here, would private parties have a concern here with regard to, the fraudulent schemes and distributing this type of information?
Yeah, that's actually where the case gets somewhat interesting because, as Justice Thomas pointed out in the dissent, the SEC didn't need to charge him under 10b-5a or 10b-5c. They could have charged him with aiding and abetting a scheme to defraud, which is typically what would have been done. Now, by expanding liability for misstatements to this kind of scheme, What the Supreme Court did is expand liability provisions that are available to private plaintiffs, because private plaintiffs can't bring aiding and abetting charges. Historically, only the SEC could, but by expanding the range of conduct that used to be considered only aiding and abetting, and in bringing it under the umbrella of 10b-5a and c, the Supreme Court has handed the private plaintiffs bar a pretty powerful weapon.
Interesting. Okay. Now, what I'd like to impart too to some of the people watching this right now, our compliance professionals, legal community, is what are some best practices here if you were to be advising firms given this decision in Lorenzo?
Well, I think the first piece of advice is, on the one hand, don't send intentionally defrauding materials to investors. But leaving that to the side, there are a lot of things I think you can do that would, if not immunize you from liability, protect you somewhat. The first thing that you could do is, when you send materials to investors, if you're not the author of those statements, you should make that explicit in the transmission material. Say, this material came from X source or Y source. We don't vouch for it. We believe it to be true, but we haven't done our own due diligence. If you have expressed not doubt, but caution about what you send out to investors, I think that's going to go a long way to protecting you. And then if there is an enforcement case, I think you should, the best way to protect yourself is to stress the differences between the conduct that's at issue in your case and the conduct that Lorenzo charged. That is, the intent to defraud, the knowledge that the statements that were sent to investors were fraudulent, and the authority or the perceived authority of the sender. And the last thing I would say in terms of that is, I think the SEC is going to push a little hard on this to expand liability past dissemination. I think that it would be important and essential to push back on that if the conduct in your case is not dissemination.
So any company that would want to distinguish themselves from this case should argue that they don't fall into this type of fact pattern, in that they were not distributing with knowledge false and misleading statements.
Right. I mean, I think there are three things that the Lorenzo case found most compelling. The first is that Mr. Lorenzo had an intent to defraud investors. The second is that he knew the statements that he was sending out were false. The third is that he held himself out to be an authority on the statements. He never said he was the author of them, but he said, if you have any questions, please feel free to contact me. So I think the distinctions that you can make is that whatever case you're dealing with doesn't have those three factors, and limit the case, limit the holding of Lorenzo to those specific factors.
Absolutely. And I see your need for that kind of disclaimer language as well would be very helpful. Thank you so much, Howard.
Oh, thank you for having me.
And thanks to all of you for watching today. Please be sure to check out our regulatory and compliance suite of services, products, and webcasts at our website. Thank you.